So we're going to call the meeting today to order the Jonesboro Land Bank here on February the 12th, 2019. And Jonathan, our director, is going to do the roll call.
Ms. Durham.
Present.
Mr. Hurden.
Here.
Mr. Hollywood.
Present.
Mr. Martin.
Present.
Mr. Mills.
Here.
Mr. Moore.
Present.
Mr. Osmond, I think, is absent. Mr. Warner's
I'm here.
here, and Mr. Zolper is here.
So we do have a quorum. So if you wouldn't mind to take just a minute or two to review the minutes from the last meeting of January 8th, and then I'll accept a motion when you're ready.
Make a motion to approve meeting minutes.
Second.
Meeting.
Mr. Herndon's the motion. Who's the second?
Second.
Mr. Hollywood, okay. All in favor of approving the minutes as written?
Aye.
Any opposed? Okay, they stand approved. So we'll move into old business. This portion of the meeting today is mostly going to be some updates, so please bring forth any questions you have as we go through it. John, will you lead that discussion if you don't care?
So I put 1444 West Huntington back on the agenda. As y'all may remember, y'all had asked to push this back until March. This is one being sold by the State Land Commissioner. They're asking $15,000, give or take. The reason why I put it back on this agenda, in April, it will be up for negotiations. So meaning we may not have to necessarily pay the full $15,000. But obviously I have to have y'all's approval and city council approval for any acquisition. So if y'all want to make a negotiated offer on this lot, we need to put something together to see what y'all are thinking about offering. And then obviously I'll have to send it through council and all that stuff before April.
So in the way of a question, we could put it together and present it back to us in March for approval. Would that work?
Yeah, I can put something together for y'all to approve in March if y'all want to. I just wanted to see, I don't know, I think we'd have enough time if we did it in March, and I got it on the second meeting in March. Yeah.
So you're saying that come April is when negotiations can take place for a lowered amount?
Yeah, so this will be on the post-auction sales list for 2 years at the Land Commissioner. Obviously, if somebody comes in and pays the $15,000 between now and April, then it's going to be off the list. But if they don't, this is going to be up for negotiation. And so I think we had some hesitations paying $15,000 at the last meeting when we talked about it. But obviously, when it's a negotiated offer, we can put whatever we want together and make that offer. No promises that it'll be approved, but I just wanted to give you all that option to do this. This is the lot, if you don't remember, that's located right across from Dollar General on G Street. Or I guess it's on Huntington. Any other questions? It's zoned commercial. So.
If anybody has questions about this property, please ask. This is strictly on the agenda today for informational purposes. I don't think it requires any action today, but if you have questions, please bring them up so John can get some direction from you about what to bring the next meeting.
Mr. Chairman, I'm just curious, what would be the use of this property? It's one lot and it's not the corner lot, and
That's a good question.
I think that's a question that we had last time. You know, exactly if we did acquire the property, what would we do with the property?
Well, as I said, it's a commercial lot. Anybody who buys it or anybody who develops the property is going to have to build it up 2 or 3 feet. Very similar to what they did across the street at Dollar General.
That's right.
It's commercial, so it's general commercial. So as it currently sits right now, any commercial project could be developed there. It's just a matter of finding somebody who'd be interested in doing it. I've not had any conversations, and nobody's been in my office trying to to buy a commercial property, so I can't really tell you any more than that, but
I think from a development standpoint, you'd want to have the corner lot as well as this lot to make it even a potentially viable development. And I understand that the corner lot may be available, but I don't know what that pricing is on that.
Nor do we. But we can look into that. As I say, I think these are all good questions and good thoughts, and we don't have to do anything about this today. But if you guys and ladies, if y'all want to drive by it and take a peek and see what you think of it, and we'll have John try to gain some more information for you by the next meeting, and then maybe you'll have a feeling for which direction you want to take it with a little more information. Would that be fair?
Oh, yeah. And, you know, I think one scenario is maybe somebody will turn around and buy it from the state and develop it themselves with us ever having to
Exactly.
touch it.
yeah.
Be a good litmus test, won't it?
There's nothing currently on the lot. It's a vacant lot.
There's as I recall, John may correct me, but there's a corner lot that has a small business that's a check cashing insurance business. Then there's this lot, Brent, behind that, and then there's a church, if I'm remembering correctly.
Yeah, this is.
It's worth a drive by, and I do think it would set our commission apart a little bit if you all do have the time to go and look at some of these properties personally, because I know that's hard to do when you're busy, but it's also brings a lot of value to these discussions.
This will be a property, as you said, it's completely undeveloped. So the city, or I say the city code enforcement, has been paying to have this property mowed. So, I mean, in the event that it's not a negotiated sale in April, chances are the city's going to take on responsibility again this summer of mowing it and maintaining it. So, yeah, but it's completely undeveloped. What I'll do is between now and the next meeting, I'm going to sit down with a couple of developers, just get their opinion on it. I'll talk to the owner of the corner property, kind of see what their direction is, what their mindset is. And I might even speak to the church that's adjoining to see what they have in interest with the lot. And then I'll bring something back with y'all at the next meeting.
And just to clarify, John, the whole reason this is on our agenda and our radar is because it is at auction, correct?
Yeah, well, yeah, it's at the state. It's been auctioned off, or it's attempted to be auctioned off for the past, I want to say 2 or 3, 4 years, something like that. Don't hold me to the exact number on that, but there's about, if you look on the offer to purchase, there's $6,705.82 worth of liens that is incorporated into that $15,000 asking price. So obviously the city's invested a significant amount of money into this property, both in demolition cost, I believe, which was a house, and obviously mowing it and maintaining it. So the city's already invested a significant amount of money in the lot. I would say if we make just any negotiated bid, no matter how small it is, at least we have a chance of maybe recouping that money, is my only thought.
So at the next meeting, we'll do our best to bring you more information, and then we can maybe make some consideration of this in one direction or the other.
Yeah.
So just to clarify, you're saying this property has been at auction multiple times and nobody has yet purchased it, correct?
Yeah, they haven't purchased it, I'm assuming, because they're attempting to sell it for $15,000, and because of the flooding issues and because of the amount of liens that the city has filed against it. I would assume those would be the 3 primary concerns. I don't know that to be a fact, but that would be my first thought. But yeah, it's been auctioned off and attempted. It's now on the post-auction sales list, and I believe in April it will have sat on the post-auction sales list for 2 years, which is why it's being pushed to the negotiated sales list. And if there's no more questions on that, just kind of keep that in mind. Think about an offer or what y'all guys would want to negotiate down to. I'll have something put together at the next meeting for y'all. Okay, and I'm gonna move on. 827 Warner, we got that approved by council back in January. The agenda says it's still in closing, but we actually closed on that property, I want to say early last week. So we now own that house as well. We're in the process of cleaning it up and trying to secure the structure. This will be hopefully one of our first projects through the land bank. We'll talk a little more about that farther down on the agenda. 501 Marshall, obviously Carol's here. She can elaborate on this if she wants.
Let me back you up just to the B item for just 1 second. So the reason we're going to talk about it further down on the agenda is we've got to look at our RFQs and RFPs, and this property will be our test case, hopefully, if that's y'all's pleasure. So we're going to discuss that further in just a minute. I'm sorry, John, go ahead.
501 Marshall, council approved that foreclosure February 5th. Carol's office is going to handle that as they get to it.
Potentially. What we're looking at, Jessica's announced that she's leaving my office. So I'm going to be looking to hire a new assistant city attorney, and with that may be some changes in job duties, obviously, to get everything up to speed. And the mayor and I have discussed hiring outside counsel through independent contractor status to do some of these things to get us started, so that things don't have to wait so long for us to be up to speed and ready to go. So that may be the case, and if that is the case, my office will work along with that person on the first foreclosure, and then I'll have my new person hopefully up to speed to be able to do them in the future. But I mean, I don't know what the time frame is on it. We should be getting started within the next month or so, making sure everything's together and getting pleadings ready to file.
The only thing I would add on top of that would be if it's successful, right, it'll go up to a public auction. If y'all guys want to make any additional bids above and beyond what the lien amount would be, then I would need y'all's approval for that and city council approval. So I think the lien that we're filing right now or trying to foreclose on is $3,000, give or take. And I'm assuming the judge would just award us that amount. So if we wanted to try to bid and take possession of the property, which I guess that would be y'all's decision, then I would need to know.
Right, what would happen is the foreclosure basically forces the sale of the property, and then anybody can bid on that property at that sale. So if y'all want to authorize, if it's a piece of property you're interested in the land bank having, you may not want to, I mean, I understand it limits you to say, oh, you know, we're willing to go up to 15,000 or whatever. I'm just making up a number. What you would want to do is give parameters maybe on negotiating, with the idea that Jonathan knows that he's not going to bid that high. I mean, you know, he should know his budget and how he can do that more so. But y'all will have to give some parameters for the bidding, and city council will also for the spending of that money. So that needs to be done ahead of the time that it's going to go to auction, so that we have parameters for him to bid at that auction. Otherwise, if somebody else buys it, the city is reimbursed their lien, and we move on.
Yep.
But we don't own the property.
Mr. Chairman, my position would be on that. It would be like almost like a bank situation. You make one bid and one bid only, and that's for the amount of the debt. Somebody else wants to pick it up after that for $1 more, let them have it. We get our money back. That way we don't put any more cash out.
I agree.
Any other comments along those lines at this point? I don't think this requires any action again today. This is information, but Dennis, your comments are well taken, and so I do think Carol advised us, but I think on the next agenda we might want to put a strategy up for your consideration.
Sure.
As an action item.
I'd need to review y'all's rules, but I think y'all need to authorize it even up to our lien amount. I mean, I think y'all need to give the authorization for the bid, and council needs to give an authorization for the bid. Because anytime you're purchasing land, it needs to be approved. So potentially purchasing land.
So once again, you know, this whole foreclosure that we've gone through here is one of our first times to try this, and so we're trying to figure out all the ins and outs. So any advice you all have, be prepared at the next meeting to discuss that if you could, please. Okay, we're going to move on to 107, 109.
So y'all, I think it was at the last meeting, or maybe it was at the meeting in December, had asked me to try to reach out and contact Mr. Wood. Those negotiations are still ongoing. The contract sits as it is.
Title issues.
We ran into some issues with the title and whatnot that we're looking at, but there's really not been any status change on that. The contract's good for 6 months. It'll expire, I believe, in May or June. So we have a little bit more time to work on that. Outside of that, any other questions, I'll be happy to answer them if you'll have any.
So whenever we get all our ducks in a row from the business side of that with the title search and all those things, we'll bring it to you for your consideration. There again, I would encourage you, if you haven't done it, to do a little drive-by of these properties and go see for yourself how this all lays out. It's hard to imagine it if you don't actually see it, so it might be worth your time. We want to move to the state land auction. Is that?
Yeah, so I was hoping they would publish the list before our meeting. I spoke to their offices earlier this week. They are not going to get the list published until late February. So the list will be on the agenda for March. Again, this is one of those situations where it's an auction, so y'all are going to have to approve me to make bids on any properties that y'all guys would want to put in our inventory. I will get that list sent out to y'all as soon as they publish it, and I would ask that, along with me, that y'all review the list, see if there's any lots that you think would be good acquisitions for the land bank. There should be several with liens already filed against them that we have an interest in. Outside of that, there's really not much more I can update on that until the list is published.
Once that list is published, can that be forwarded to the commissioners
Yeah,
prior to the meeting so they can begin to consider?
Yeah, as soon as it's published, I'm going to send it to y'all's email. Y'all guys can start looking at it, and if you have questions, get with me on that.
The thing is, with that auction list, people will pay their taxes once that list is published. I mean, it will, even if we would have gotten it before this meeting, it will change drastically between now and that auction date. So even if we get one in March, what will actually be there to discuss that second week of April will probably be vastly different than what was already on it. There'll be a lot drop off.
So Jeremy, just walk us through the timeline a little bit different. So if the auction is on this April 17, you can actually do something April 16th, right? If you were an owner.
Yeah, I mean, people will sit there and pay up. The closer it gets, the more that you'll see where the auctions are canceled on it. So that list will be cut down drastically the closer.
Even up till the day before or up until the time.
Even after it sells,
Sure, they have time after it
still
sells
going to
too,
be
but if it's
able
going
to
up
come
to.
back and redeem the taxes. So that's why I'm saying we just because y'all approved the acquisition at this auction doesn't mean that we'll ever put the property in our inventory.
A lot of steps to go through.
Yeah, it's just I have to have y'all's permission to bid. So if we have any chance at getting it, I need to send it through the commission and the city council.
Makes sense. Yeah. So we'll try to get that list out, and then y'all just peruse it, and then we'll talk the next time about if there are properties you're interested in, with the full understanding that we may never see those properties.
If that's the case, would you like to revisit that list sometime in April? From the calendar, like April 9th is the land bank meeting for that month before the auction.
Yeah, I'll have it at the April meeting. The auction's not until the 19th. So
17th, it says. Is that wrong?
or the 17th. Yeah, the 17th. So I'll have it at the meeting in April as well. But the problem is I have to go through this commission and then city council. So, if you wait till March or the beginning of April to make any decisions, it may be pushing it to get it through council in time, especially if you wait until April 9th.
You won't get their counsel.
Yeah, I won't get it through council if you wait till April 9th to make any decision. So March is kind of our cutoff for decision-making on that list.
But we will have the list by March.
Yeah, you'll have the list hopefully by the end of February.
Okay. All right, so we're going to move to staff report for accounting. Trevor, are you wanting to address that a little bit?
I don't have too much to say today, but we, have started our new budget year. We have a budget update that I gave to Jonathan at our last meeting that talks about January's numbers and where we're at. It's a little bit interesting when you look at everything that can happen in 1 month.
I'll pick up from where he's kind of tag team with him on that. Everything that we approved, even though we approved it back in, let's say, December or November, it wasn't when we approved it, it was when the check was issued. So long story short, we started this year with 25,000. All of the approvals that we did last year and this year went through this year, so they took that money out of our account. So we went from 25,000, I think, down to 9,000, give or take. So that 15,000 is also a little bit outdated. But yeah, so I can take it tying into that as well. So if you look, those closings, they're done. So we now own 4 properties in our inventory, 2 existing houses and 2 undeveloped lots. That's kind of where the financial, the money went to, is getting those 4 properties.
And maybe, excuse me, maybe you and Trevor could discuss just for a moment the outlook for these properties, because we don't plan to hold them for a great long time, and they do have potential to put money back in the land bank at some level. So do you want to talk about that for a second?
We have talked a little bit about, any property that has a lien on it that we purchase, even though the purchase price is going to come out of this account here. When we receive the reimbursement for our liens, we'll move that over. So when you look at your department budget total, it will have some offsetting entries for whatever liens we get paid for on the properties that you purchase.
Or, Trevor, I guess also sales, correct?
And sales, correct.
Okay.
And we talked yesterday as well about when we do these, we'll get down to this at the very end, but when we solicit RFPs for some of these projects, one of the considerations will obviously be how much they're willing to pay. So we should be able to recoup, as Dr. Warner was saying, some of that money back through the sale of the property as well. So
right.
I don't think it won't go right back into the land and improvements account though, right? It'll go into a revenue account.
There'll be an offsetting account. Yeah. The land and improvements account will just be the purchase price for whatever land we acquire. But there will be an offsetting account to, bring the bottom line to where it needs to be.
And I guess I'll just, everything obviously in the inventory is listed here, 115 North Drake, 113 North Bridge. I would ask this to Jessica and Dennis, maybe anybody else that would know the answer to this. The State Land Commissioner, they issued us a 90-day litigation, or not a 90-day, they issued us a limited warranty deed, and it's currently in a 90-day litigation period. They mentioned to me, and I don't know where we go with this, but they said we would want to do some sort of quiet title action before we could sell it, develop it. What are y'all's thoughts on that? How much would that cost? Is there a time frame on that?
There's a time frame. I mean, there's a time frame on any of it, obviously. I'd have to look. I just need to look at it and see why they issued us, what they think the concerns are with the title. But we can look at that and see.
I think all deeds is what I got from them is all deeds issued from the State Land Commissioner is
going to be limited warranty.
Limited warranty deeds.
Right.
You can turn around and come back
And fix it within the 90
pay the
days.
taxes and the back down, and then they get issued the property back.
But after the 90 days,
So what's the cure period on that?
Need to go to a quiet title because
I don't either.
I think it'd be one of the, apparently if we want to sell it within that 90-day frame.
Then you would
which
need to.
I don't think anybody would be interested in buying it within that 90-day.
Well, we wouldn't be interested probably in selling it. So
We wait till
what's the
90 days.
cure period at 90 days? Then it's free and clear. Is that right, guys?
It should be after 90 days, us having a
The
claim
liens.
warranty date on
Yeah.
it.
Okay.
But if that's not the case, we can figure it. I need to look at the liens or at the deeds and see what they're saying on them, and we can figure that out.
Okay.
But I think you wait your 90 days first, and then we discuss it.
And if it is involved in any other negotiation for any other properties, we just have to stipulate that we've got 90 days before that can come to fruition. Is that right?
Yeah, well, yeah, the 90-day period is, you don't want to do anything, but actually the big companies that buy this stuff, they will do a quiet title. And that sort of seals it. And there's some guys out of Little Rock that buy a lot of this stuff. In fact, they own a cemetery down there. I've dealt with them before on some properties. But that's what they do. They'll quiet title, they'll buy it from the state, but they'll quiet title, and then they'll put it on the market.
So we would have an opportunity, Dennis, to do that later down the road should we need to. Is that right?
Yeah, you can do it.
Carol, is that right in your mind? Okay.
There should be a court order that says you own it.
Right. Nobody can show up with a lien later that you didn't find on anything. I mean, it's,
And just as a matter of information, if someone were to obtain the property from the land bank, they would have the option to do that, correct?
Correct.
We don't necessarily have to do that. Is that true?
That's true. I mean,
So we just,
we would not give them a warranty deed.
so we could
that's
make
for
a
sure.
stipulation that that's something that we'd ask them to do in certain cases. Would that be fair?
I don't know that we have to stipulate that they have to do it, but what you would want to do it, you'd want to sell it to them and say, you're going to give them a quick claim deed.
you'll be transferring our interest and not, it wouldn't be a warranty deed that you give.
So you just do that.
Okay.
That's the difference in a quick claim and a warranty. You're just giving your interest in the land. You're not saying you really have any. If that makes sense.
That's way beyond my pay grade, I think. Okay. Does anybody else have other questions about that particular issue? Trevor, do you have other things you want to tell us?
Not today.
Well, we appreciate you being here to help us. So at this point, I think we're just going to move to letter B, John, unless you've got something else on those other properties.
No,
So we anticipate this will take a minute of discussion and maybe some action here too. So I'm going to let John kind of
so I'm going
tell
to,
you some dates and what we're thinking.
so this is going to be discussing, if you look at the paper that you have, required qualifications statement. I just titled it and put this together so y'all would have something to look at while I talked. So we've decided to set a meeting with developers for February 21st. And what this is going to do is it's going to be kind of like a question and answer session. It'll give local developers an opportunity to share any of their concerns or answer any questions they have before they submit their RFQs to the land bank. And what we're going to do is we're going to take essentially a panel. We're going to look at the developers that show up who have interest in partnering with us. We'll do RFQs and they'll submit that, and we'll pick from those submittals a group of developers for year 2019 that we will obviously solicit RFPs from. So that's what this is starting. Projects like 827 Warner, this will be the starting point to finding a developer to rehab that property. I got a list, obviously, of qualifications that I feel like developers need to have. Y'all can add or take away any qualification that you don't feel like needs to be on there.
Well, let me ask a question about that. So most of these came from our guidelines, correct?
Yeah.
Which are already approved at the city council level.
Yeah.
So in order to change this do we have the option of changing some of these, or we just take them off of this document? What are y'all's advice on that?
This is what I'd have to review your rules, but if this is what your rules say that you were going to require in a developer, then if city council has approved, y'all approved those rules and city council approved those rules, then you need to follow those rules. So
All of
there
them,
might be limited changes you could make, but this is basically what y'all agreed and decided at that time you were going to require. Is that
number 1 through 5 is, I talked to our staff, our planning staff, engineering, internal departments, and 1 through 5 is ones that they recommended. They're not necessarily in our bylaws or redevelopment plan. It wasn't approved by council. I just added them in addition to what we already had. So, yeah, and I agree with what you're saying. If it's already been approved by council, then we need to stick to it, so.
As much as possible. I mean, some of these are just common sense that we require of any applicant, which is a Jonesboro business license and that they're a licensed contractor in the state of Arkansas. I don't think you have to send that stuff back through.
Bonded. No.
Yeah. So, but if there's anything major that you want to change, we need to look at it and consider it.
Has everyone had a chance to sort of review this list?
And one more thing, too. The actual paper here, I don't know how we want to handle it, but I would suggest having the developer, when they submit their RFQs, sign this at the bottom, obviously stating that they understand and they meet the qualifications. That'll prevent me, obviously I'll do what homework I can, but there could be the chance that I miss something. I want to be able to hold the developers accountable, saying that, they've read this and they understand that these requirements must be met in order to participate in some of our projects. In the event that staff overlooks something, we can fall back on this document.
This is ultimately a pretty important discussion because we do plan to hold the developers who are interested in working with the land bank to these standards.
Jonathan, I know on number 4, it says include 3 letters of reference. Would it be easier, make more sense if they just went ahead and included their Jonesboro business license, a copy of their contractor license, and a form showing that they're bonded at the same time where they just have a complete package? It doesn't say included, and this is just must have. I'm thinking that'll probably save you some steps and heartache also.
So just a kind of a syntax change to say, so they all are worded like
Like number 4.
yes.
So
Applicant must include a Jonesboro business license.
the RFQ should include all that.
Sure.
Yeah, that makes sense.
So it's just a question of changing the verbiage.
Yeah.
Okay. I don't think that requires any action. It's just a practical issue, isn't it? Okay. Does anybody have other questions or discussion about this? So the premise, John mentioned this in his remarks. The premise is that you come to the meeting and the date, again, tell us the date.
The date is the February 21st. I believe it's a Thursday. We're going to start at 7 p.m.
And it'll be here.
It'll be here.
And so you must attend this meeting if you want to be considered to be on our list for the coming 12 months.
And if you know any contractors, developers, or subs that would have any interest, please let them know.
Keith, we would solicit your help at the paper if y'all could get the word out. It'd be very helpful. We want to be inclusive. We're not trying to be exclusive. So
I've sent out as many letters and local developers and contacts that I have, but I'm sure I don't have everybody. So if you know of anybody that would ever have an interest, in just let me know or please contact them and tell them to be here.
Mr. Chairman, one thing I think might be a limitation would be when you use the term licensed contractor, unless you define it, all you're talking about building contractors. They would, real estate development companies, realtors, they wouldn't be a licensed contractor, not in the state of Arkansas, because there is no license for them. Now, they might have a real estate license, and a development company, they wouldn't need anything. Typically, they are a licensed realtor, but that doesn't mean they have to be. So that's something to think about as to how wide of a net you wish to cast.
The reason why I put that in that form, and this goes back to the permit process. We have an application that people have to fill out when they're applying for any type of building permit, whether it's a fence or a house or whatever. Mm-hmm. If you're doing it yourself as the homeowner, as the landowner, then you can build yourself a personal house without a contractor's license. If you're building a house on behalf of somebody else, I think we require that you have a contractor's license in order to pull the permit.
So let me ask a question, Dennis. I think I know where you're headed. So if we have a piece of property somewhere and we want to put an RFP out that, fits the land use plan that we've conceived for our revitalization of an area, we want real estate maybe companies and developers to be able to adhere to an RFP just the same way a contractor would. Is that what you're saying?
I would.
Is that the loophole that we want to close? Is that what you're after?
That was what I would think, is that you would want to include a broader spectrum.
They would buy it and resell it.
Well, they might buy it and resell it, they might buy it and develop it, I don't
They're a
know.
development company.
Well, the premise, in my understanding of the land bank, one of the great advantages that we have to offer is that we take property into an inventory, we put it outside our inventory into someone else's hands with some stipulations that meet the goals of the area we're trying to help. And so if you're going to do that, the net's got to be a little wider. Is that what you're?
That would be my opinion.
Does anybody else want to talk about that aspect of this? Carol, do you have a comment? It's okay if we want to broaden it out, correct?
I mean, it's up to you who you're turning property over to. So yes, if you want to include development companies or.
And there was one other thing too, and I didn't really know how to put it on here, so we didn't. But in the event that we get RFQs and for whatever reason there's not an individual that we feel like is qualified for a project that we have, we want to incorporate the ability to have exceptions. Or let's say somebody doesn't live in the city limits of Jonesboro. Let's say they live in Bono, but they do a ton of business in the city limits of Jonesboro. We want to be able to have that exception. And so
What number is that?
there's number 9. I put that they can make an exception or make an application out to get an exception from y'all guys. Are y'all okay with that? This is one of them that, I don't want to limit us if we don't get the right type of RFQs.
Well, the thinking was just trying to look forward with some vision that some of our projects won't be a renovation of a house or rehabbing a house. It may be a bigger project. And if the people that we have qualified through this process are not, don't have the expertise, then you all will need the ability to add to the list. Did I say that correctly?
Yeah.
I mean, the way I understood that this process would work, and granted, I haven't been hands-on this, Jessica has, but obviously, if you may have different qualification statements that you put out for different types of development.
That's
So,
the next step.
so this wouldn't necessarily cover maybe commercial development. Maybe this covers residential development. Maybe you have something different where you put out for different.
So Carol, I think I understand this. So what we're planning to do is this would be for the informational meeting to qualify people to work with the land bank based on these criteria. Mm-hmm. And then individual projects would have an RFP, which is what you're alluding to. And then should none of the developers or entities that have been identified can deal with that project because of expertise or non-interest, we still need an exception to come back and add to this group. That's what we were trying to. Does that make sense?
I guess it kind of goes back to Dennis's comment on how broad a net you want to cast. If you're limiting it to them being a resident of the city of Jonesboro or this being their principal place of business, you're narrowing your net.
Right. And that's why we put this in, because a couple of people have mentioned that we may need somebody, for instance, out of another city that has a certain expertise or an interest or do a lot of business here.
But do you want that to be an exception, or do you just want to broaden your net to begin with?
Well, I think
That's my question.
the stuff that was approved by council says they have to be within the city limits.
Okay.
Are you talking,
So you already narrowed your net.
wait just a minute. Where do you find that at?
Is that in your rules?
Yeah.
It's in pro.
See it under the rules I'm looking at.
I don't
Have you
have
found
my
anything? I know
That's why I asked the
I know this discussion is dragging out a minute, but y'all bear with me because this is extremely important.
Governing acquisitions? There we go.
I think it's so, say,
a developer buys a piece of property from us, we're gonna put stipulations on as far as what they're gonna do or how. If they turn around and decide to sell that piece of property beforehand.
We have to make sure it's with those stipulations.
it's gonna be-
It follows
those stipulations
it.
are gonna follow that
Follow it.
To whoever the new
It's like a
purchaser.
covenant in a sense.
Whether you're,
You have to make sure whatever stipulations you put on the property would follow it in a resale. Otherwise, you've defeated the purpose of the land bank.
Otherwise, maybe
That's the
come in
case,
and
you-
buy the piece of
Absolutely.
property, turn around and resell it.
So it's just a waste of
I
time.
think it says exception, and make an application for, to see that.
You
That's
need
what I
to
came
go
from.
look at that, Carol. You need to see what they're talking
I mean, it's set the way it is, right?
about.
I guess so.
That's how they approved it.
Yeah.
Dennis, what do you feel?
Jonathan pointed out to me under the rules and that the city approved and we approved, under land transfers, number 10, it says just what that exception, or just what.
Yeah, this was taken directly from our guidelines. I think the point of this.
Whether it's good or not,
That already.
time will tell.
Well, and I
Well,
guess that's what you look
That's why
at.
we're looking at an exception. So if
Well, I
you
don't-
do need to,
I think you should follow your rules the way you have them written right now. And if
Yes.
that's in those rules, then not an exception. And when the time comes that your field is not what you need it to be, then you look at changing your rules.
so would you suggest in this document that you take that out?
Well, the rules that we already have say, there is the ability to have the exception. The exception is in our rules.
Yeah, the exception is in the rules.
So the way it's-
Right.
I-
It's just verbatim.
Yeah.
This is pretty.
I essentially copied and pasted that section right into this document. So what you're reading is in our rules.
I'm not a big fan of exceptions legally. I would rather the rules
But you love
change.
consistency.
Yeah, I like consistency.
Yeah,
and
we
I
know
like
how
rule
you are.
following. I don't like exceptions a whole lot. But I mean, obviously, there may be a piece of property that comes into the land bank that's just an unusual beast that you need an exception built in for. I just think there's a reason they call it exception. It shouldn't be used.
Well, and I think there's some
Very often.
stopgaps, aren't there, Carol, too? If it's an exception, we have to approve it. City council has to approve it. So ultimately, we're not losing anything, I don't
Right.
think.
Okay.
Can we, I'd like for everybody to have a say about this. Does anyone have any other comment? If not, I'm ready to take a motion. Anybody have other comments?
And the motion would be to, I guess, approve this document
As amended.
And look at, I guess, the legal statement I have at the bottom. That's just me. Is there anything legally wrong with that? I mean,
Nothing legally wrong with it, no.
all right.
It's just a statement. I mean, obviously, to me, their bid packet is more important than this piece of paper. I mean,
Well, let me put that in perspective as we are understanding this. So the first step, if you're a developer, a real estate person, a contractor, is that you would come to this informational meeting. You would put your packet together that Jeremy mentioned, that there's a full packet. And then those developers will be accepted developers or contractors or whatever term you want to use to work with the land bank for the next 12 months. And so then the RFPs, which will be the individual projects, go out to that group. Am I saying this the way that everybody understands it? You guys okay with that? And the reason, the logic for doing it this way is that there's other models around that do this, but we don't want to have to vet for every project that you all want to pursue. We don't want to have to vet a whole new group of developers.
And before we make a motion to move on with this, are y'all okay with setting the deadline to have those RFQs submitted Friday, March 8th? Our meeting for March would be the 12th. So that would give us from Friday, March 8th through Tuesday, March 12th to review the RFQs and I guess make a decision in March to approve them. If that's something y'all are okay with, I'm not sure if that would give everybody enough time. Or if y'all don't even want to be a part of the approval process, staff, I can review the RFQs and and approve them however y'all want to handle it.
Well, I think what you want to do is at least bring a list to say you vetted these and the
Packet's
commission
complete.
and the commissioners can then say,
I mean, we can vote in March, in April, correct? I mean, I don't think a month's gonna make that big difference.
well, or we can vote in the March meeting if Johnson's ready to bring the packets to you.
I was thinking to give us time to look over them if anybody wanted to
Okay.
look over some of them.
Yep. And I think that what's hanging out there as a good thing is this 827 Warner property is kind of the one where we're going to walk through this process. And so it can start, there's no deadline for it really. The only pressing issue with that property is, as my understanding, we've talked to code enforcement and to the building officials, and that property has to be secured, and we're in the process of getting that done. Make it safe for the neighborhood while we're figuring out what we want to do with it. If y'all haven't driven by it, you ought to do that, or if you get out and walk inside, be very careful. What's that, Carol?
I said if they were discussing, I think number 2 still down here, and I said if you want to make a change to include something beyond a licensed contractor.
Yeah,
now's the
absolutely.
time.
Somebody make a motion and let's make the changes that you all want.
Well, I'm just saying that
Right.
I don't understand why we would not want a broader spectrum of people who might be interested in buying property.
I don't think anybody's opposed to that. We just didn't think of it. So you're good.
So
Just,
let me ask this, can they still buy property from the land bank? Buying property is one thing from the land bank, but us soliciting a project is another, right? So like any resident from Jonesboro can come and purchase a property from our inventory if they want to build a house or whatever, am I correct? This doesn't limit who can purchase from us. That what this does is it creates the pool of applicants that I can then approach and say, we want to rehab 827 Warner, submit an RFP.
so it's probably a different way of looking at it, Dennis. John makes a really good point. We don't want to limit real estate people to having to have come to this meeting and be approved. You see what I'm saying?
Yeah,
So where you'll catch, let me just ask this question. So where we catch keep the land bank's purpose in our mind is not in the RFQ with real estate people, but in the RFP. So an example, and I know this probably isn't going to happen, but let's just throw it out there. This Huntington property, we've all been kind of batting around. So let's say we do get that in our inventory. We attach an RFP to that immediately, that if you want to buy that from the land bank, then here are the things that you have to do. So this is more about vetting people for their qualifications. Can they actually do the work? Are they bonded? Do they have the right materials, the right equipment, the right staff?
I think for me,
Is that right?
Yeah, for me, the RFP is going to come in. It's me actively soliciting for a development project. Without the RFP, we'll just get 827 Warner and it'll just sit in our inventory until a citizen of Jonesboro decides they want to rehab it.
But by the same token, let me ask this question so we fully understand. If we have a piece of property that's undeveloped and we want to put it, everything in our inventory ought to be put up for sale at some point, because we're not in the business of holding property for no reason. But the RFP attached to those properties have to guide toward what we would conceive as a master plan in an area.
Yeah.
So in other words, you can't just come buy the property. What I think Jeremy said this, someone said this earlier, we don't want to become a vehicle for a real estate person to come pick up a cheap piece of property and do what they want with it. We've already got that model in the city. And so what you're wanting to do is develop these properties in a meaningful way for the community and for the taxpayers. Is that making sense? Am I saying that correctly? So I think you can, Dennis, maybe we can pick up your concerns with the RFPs attached to the properties for the real estate and the developers. And maybe this would be limited more toward contractors and people who are actually going to do the project.
Let's just make sure we're clear because I need to know
No, I think that's why we've got to spend the time.
how to word this before we
I guess here's the question. If for real estate. Y'all need to,
Talk in the microphone so that everybody. They may have a question about it, and I don't know what you're saying.
We've just been talking about this concept that you all are struggling with, and I'm struggling with even more, because we don't, unless it's hidden someplace in our priorities and policies for property acquisition and disposition, we're either acquiring property or we're disposing of property. It doesn't say anything about development property. We're not developing any property. So if we're going to transfer property, it's going to be to a user. Could be a flip to somebody else that's going to maybe flip it down the road. It could be to that neighbor next door on side yard dispositions. It could be to somebody that's contiguous to us that wants to buy a lot. And what I'm having is I'm struggling with is this request for qualifications, request for proposal, where I don't see we even have the authority to do that. And if you're going to have a request for if you're just talking about request for qualifications to transfer, if you're just talking about that, then we want to have a broad base. We want to have everybody possible, individual owners, developers, real estate companies, contractors, licensed or unlicensed. Because if you're buying it for yourself and you want to build something, you don't have to have a license in Arkansas. You can be an unlicensed contractor. So that's what I'm.
I think we're.
Mr. Chairman, that's why I'm. Confused.
Yeah, I heard everything. Let me maybe clarify at least my understanding of this. So let's use 827 Warner as an example, which is what we started with, right? So we have as a group, we will make a determination of what we want to see happen to that property. And I think when we bought it, you all may recall it's on a 50 by 60 lot, which if it were, demolished, that becomes an incredible coding, what's the right word? Zoning problem.
It's non-conforming.
It's non-conforming. And so again, and I don't want to speak for the commission, just down the road. So when 827 Warner comes up, which is the next step from this, you all, at your pleasure, will put some stipulations on that property. I'll tell you what my thoughts would be. So it has to remain a single-family home. If there's some environmental issues, they have to be dealt with. I'd leave this more to Jeremy and those of people who develop properties, but the point being that we put some stipulations on that. So at the end of the day, we sell that to a developer, or as you said, Dennis, maybe to the neighbor, right, who wants to have the house and do it themselves. But they have to meet the RFP, not the RFQ. What we were attempting to do, and based on some other models of land banks, is to have a pool of qualified contractors that when they're needed or if they want to be part of the RFP. So here, let me back up and say it this way. We put an RFP out on 827 Warner. So all those people that, in my mind, that you just reeled off would have a shot at that property. But whoever it is, whether it's the neighbor or it's the contractor, they would have to meet the RFP that you all have put on the property to be sure that what happens to that property is what we conceived should happen to it as a group. That's the whole value of the land bank. If we're just going to flip property without any stipulation, then all we're going to become is people who buy cheap properties and we flip it out to somebody else and then they do what they want to with it. We hadn't accomplished our goal of revitalization of an area. My opinion. It's just my opinion. So I'm wondering if we're not muddying the waters by the two different documents. This is simply to vet anybody who comes to us and wants to do business with the land bank as a viable, legal, competent contractor. But that doesn't exclude real estate developers or real estate agents or even the neighbor to come and buy a property. That's another step, in my opinion. Now, I'm not the lawyer in the group. I'm just telling you what our concept was.
Would it make you more comfortable with this paper if we just eliminated the licensed contractors aspect of it? If we just deleted number 2 and just left it? I guess my other question is, when you made your statement, are we even allowed to ask for RFQs?
What it says here in the policies and procedures we've already voted on, it does refer to when it says where rehabilitation or development of property by a transferee, somebody we're selling it to, is a condition of the transfer. In other words, we're going to condition the transfer. The requirement shall be in accordance with the transfer agreement. Now,
I think that's where this is.
Whether that's, if we're going to use the correct terminology, probably we should refer to transfer agreement
Well, let me ask this question,
so that there's a consistency.
and maybe I'm off base on this, but my understanding, and I've read that as well, is that that's not referring to this. This is simply if you, in my mind, a housekeeping issue where we know that the contractors that we've looked at are viable contractors. And here's the antithesis of that. I don't think that you want to, if your pleasure is for 827 Warner to be rehabbed in a certain way, whatever way that might be, you don't want somebody to show up before the land bank in John's office and say, I have a toolbox, I'm going to go fix this, and I'm a contractor. So rather than John having to vet every person, this one would identify, one, who's interested in working with us toward our goals, and 2, who's qualified to do that, just for the contractors, not for the neighbor, not for the real estate agent, not for the developer.
Let's just drop that.
Does that make sense?
Let's go ahead and have a vote.
Well, does that-
It's not a big deal for me.
Well, does it make sense, though? Because, I mean, we want to get this
I understand
right.
what
This
you're
is
telling
pretty
me.
important.
What you're telling me.
I don't want to do something on the 21st that we don't need to do, so I want to make sure it's right.
Well, let me propose this then. If there's concern about it, why don't you just say on the 21st, you're having your informational meeting where you can just educate people about the land bank and the mission of the land bank and what the land bank wants to do. And then after that point, at your next meeting, you'll get your, whatever you want to call it, whether it's a required qualification statement, whether it's, any kind of application for people to submit their interest, you get that ready and send it out after your next meeting.
Like I said,
If there's
it's not a
concern.
big deal. If that's all you're wanting to do is just get a list of people who are interested in maybe working with the land bank, call it whatever you want to call it.
Yeah, I think that was the motive, just to save a lot of paperwork each project.
Okay?
And then to offer in 12 months a chance, if somebody wasn't on the list, to be added to it. And then we also thought this exception was important because 6 months from now, if you come up with a project
It's commercial.
that's commercial, for instance, and we don't have a commercial person who said they're interested, then we'll have to make an exception.
That's fine.
Does that
That's fine.
more sensible?
I'll make a motion that we approve the request for qualifications.
Okay.
As amended.
As amended.
Yeah, As amended.
Is there
All
any
right.
way we can,
I second.
We'll get the amendments,
what are
yes.
the amendments?
The amendments were to change
That's next.
where they are required to provide their business license, their license for their contractor license, their bond, instead of just saying they have to have it, to say they have to provide it in the packet.
Just say so they bring it to you. Does anybody is there a second, by the way?
Just a second.
Thank you, Jeremy, seconded. Is there any other discussion? All right, all in favor?
Aye.
Aye.
Any opposed? Did you guys vote down there? The attorney's asking.
I didn't hear one word from that end of the panel.
Aye.
We're
My
going,
only question is,
Okay, so we voted, but you
y'all
still
voted.
have a question. It's
Can I
okay.
still ask a question?
Absolutely.
That document does not limit who can purchase one of our properties, correct?
Not at all.
Okay.
All that document does, Brennan, in my mind, and I'm not the authority, the attorney can tell you, is it just says that if someone comes for us at this meeting, makes application, that Jonathan will be able to say they're one of our vetted people, that we know they're qualified, so that you don't have somebody who doesn't know what they're doing, picking up a cheap piece of property and not meeting the goals that you all set for that area of the city. Is that making sense?
I agree.
Okay. And so, let's see, that's all we're doing today, John, is that right? So let me just give a preview of coming attractions, if I will. So at the next meeting, we will probably put on the agenda the concept of the RFP and how you can use that. And so that would be the thing that's attached to the individual properties as we acquire those. And by the way, if anyone has additional agenda items, please let John know so we can get them on the next agenda. Does anybody have any further business?
I don't see anybody here, but you have public comment.
I'm going to do that. I hadn't forgotten. Any other business to come before the commission? All right. So we'll do some public comment now. We have a little public here today. So does anyone want to say anything? Do we have to wait 3 full minutes, or is it
No,
okay?
you're good.
All right. I'll accept a motion to adjournment. It does not require a second.
So moved.
Dennis moved to adjourn. All in favor? Opposed? Thank you for your time.